All rise. The Court of Appeals, Division 1 is now in session.
Thanks. Please be seated. Good afternoon. We're here for oral argument in Harrington v. Circle K. It's our CV24 0012. As you may know, we record and live stream these proceedings, so before you begin and when you approach the podium, if you just tell us your name and the name of your client. You each have 20 minutes per side to talk to us about your case. We don't require that you use all of that time, but we do require that you keep your own time, so if you'd like to reserve time at the end, that's for yours to keep. Keep in mind that we have read the briefing, we've studied the record, and we conferenced the case this morning. So with that, you may proceed.
Thank you, Your Honor. I will try to remember to save myself about 5 minutes if I can keep looking at the clock and multitask here. I need to move this up just a little, if I may. I don't want to. There we go. I'm Wade Causey, and I represent Circle K. Circle K is the appellant in this case, the defendant at the trial court level. There are basically 3 major issues, but 4 as they are briefed. And just to summarize those, we have the trespasser and the invitee issue. I refer to it as a Nicoletti issue because over my years, that's kind of the case that deals with most of those related issues. Then we have the identification of the unreasonably dangerous condition. And then the notice issue, which is a little bit tied into the video, as I'm sure you could tell from the briefing. As far as the trespass invitee issue, there are 3 primary cases.
Can I ask you a question about that before we begin?
Yes.
Were you required, you argued a JMOL at the close of the plaintiff's case in which you raised the trespasser and the invitee and the unreasonable dangerous condition issue. But then when you renewed your JMOL after the jury verdict, the only thing that you raised was the issues, I'll say, surrounding the video, the counsel's argument and whether the video should have been referenced at all to begin with. And I think arguably you also addressed the 4th issue. But I'm wondering, doesn't the rule require that when you're doing a renewed motion that you include all issues in order for it to be ripe after a jury verdict?
I don't believe it does. I don't think it requires all issues, which would mean you would have to bring into that motion every issue and objection to evidence.
No, I'm simply saying that because you raised it at the end of the plaintiff's case, doesn't the rule require that as to those issues, they're renewed after the jury verdict? Let me look at the rule here.
I apologize. I'm not sure I understand the question then.
Sure. You keep going, and I'll look for it. I don't want to take your time.
Okay, thank you, Your Honor. The key when you're looking at the scope of the invitation in a premises case the analysis starts with the premises owner, the property possessor who's in control. In this case, it would be Circle K. The reason we start there is you first have to find out, well, do they claim that this is an area that's not open to the public? A lot of these cases regard ingress and egress, but we also have areas inside places that are not generally open to the public. So we start with that analysis. Circle K claimed from the very beginning, obviously, there was even a motion for summary judgment, that this particular freezer area, the ice freezer, was not open to the public. It's not an area within the store that people are supposed to enter to do their shopping.
But how is somebody supposed to know that? There was no signage on the door saying do not enter. I'm not saying there should be. I'm just saying there wasn't. If there's no ice there, how do you know that it's not okay to walk in and get it?
Well, they look to the setup because as soon as the possessor of the property claims it's not over the public, the next issue is whether or not there's implied invitation. In other words, did the property owner do something that either negligently or intentionally, that leads the person to reasonably believe that it is open to the public. So we look in this situation at the conduct of them and the evidence that was presented at trial or was not presented at trial, and the physical setup of the property. And that's what we look to. This is...
Didn't Mr. Harrington testify that he had been in the ice freezer multiple times before?
He did, but he never testified that he knew that anybody from the store had seen him go in there and failed to say something to him about it. And that's what's important in Nicoletti. And it's in one of the other Southwest Cotton, and that's because what they're talking about is the proprietor, the business, the property owner, has to have engaged in some type of conduct to lead the person to reasonably believe that it's open to the public. And that's what the implied invitation is. So in this case, it would be, and the example that's given in the MGA Theaters case, and this is the distinction that was brought up by the Supreme Court in the Nicoletti case, distinguishing that case, is that they knew that people were going in there and never did anything about it. Whereas in Nicoletti, the court points out, well, they couldn't have seen everybody that went through that area. It's a shopping mall. They would have to monitor it 24 hours a day. They couldn't have seen everybody that went through there, but the ones that they did see or knew about, they admonished and told them not to. And that's the factual setting we have in this case. The store manager, the only person that testified to anything about this issue, said, if I saw somebody go in there, I would admonish them and tell them, don't do that. If you need us to pull ice forward, then ask us for it. And then you look at the physical setup to fully address your question. You've got a frame to a door, that's metal frame, that's 4 or 5 inches high. So you don't have just a walkway through a door that you would open with a flat walking surface. So right there's arguably a tripping hazard that you wouldn't want somebody to go through. And then just inside the door is a wooden pallet. Okay, so obviously it's our position, and you're going into a dark freezer that doesn't have lighting inside, that's kept at 5 degrees below zero. These are not ideal shopping conditions. Okay, so I don't think that it's...
But the fact that it's not ideal shopping conditions doesn't mean that there was sort of no indication that somebody would potentially go in there or could go in there.
Oh, there are lots of places that are not open to the public in businesses that people can go into, and there's no signs on the door. I often...
Right, but a reach-in cooler at a convenience store for a bag of ice, you're saying that that's not natural, that someone might reach even further into a cooler to grab a product in a convenience store?
Well,
Particularly if it's not readily available.
Yeah, I think you would ask, I envision it in the terms of, let's say, a grocery store and there's green beans on aisle 7. If there aren't any on the shelf,
But that's not a good analogy when there was ice within their sight line that was just one step into a cooler to grab. Anyway.
Yes, one step on a wooden pallet and then across, the frame bar there. It happens more often than you would think. I mean, the areas, for example, at most stores where there are retention basins, people cut across them all the time. And to say whether or not you would expect it or anything, I don't think it's the legal standard. Actually, people will do a lot of different things. The standard is about the scope of the invitation and whether or not the defendant, in this case, Circle K, has engaged in action that would lead to that reasonable belief. And there wasn't any really evidence put on at trial as to that issue. And that's why we believe that in this instance that the plaintiff would have been, there's no evidence that he was not a trespasser and that he instead was an invitee.
Right. I'm going to turn you back to what I was talking about before because I know your time's going quickly. But ARS 122102C says that is our jurisdictional statute. And so my point was that in your post-verdict renewed motion, you argued only that, and I have it in front of me, it's IR 154, that there was a lack of notice and evidence of the missing video footage was inadmissible. But there are cases, Williams v. King, 248 errors 311, Acuna v. Croak, 212 errors 104, which tell us that we lack jurisdiction when a mid-trial motion is not followed by a post-verdict motion preserving the issues for appeal. And so that's my concern, is whether we even have jurisdiction to address your invitee or unreasonable dangerous condition issues that you raised in your first JMOL but were not renewed.
I understand it. I'm not familiar with the provision at this point. I don't
Okay.
have it in front of me.
Fair enough. Can we focus then on notice and
Yes.
and the video?
Yes. The notice issue, first of all, we got to tie it into the unreasonably dangerous condition. The trial judge specifically asked counsel at trial, what's your unreasonably dangerous condition? And the interesting part is on page 6 of the response brief under heading 3A, plaintiff still says, well, it was either the ice or the pallet.
Right. But my
Okay.
question is, I think the root of your argument is that you didn't have notice under any of the three ways you could have had notice. You didn't create it, you didn't have actual notice, you didn't have constructive notice. And in the briefing, you addressed that plaintiff basically conceded that you hadn't created the unreasonable condition in an out-of-the-jury hearing in front of the judge. But my curiosity is, when I look at the jury instruction, it wasn't narrowed for the jury. All three options were given. You didn't object to those options being given. No one said, hey, judge, this one's out, so let's just make them. So the jury didn't know anything about what had been conceded or not conceded, and they had the option, based on the evidence they heard, to find notice under either of those three categories, correct?
Which takes us back to the identifying of the unreasonably dangerous condition, exactly.
Right, but you didn't have any kind of interrogatory to make them tell you what they thought you didn't ask them to identify an unreasonably dangerous condition in an interrogatory or in any other way. So you don't know what they landed on, but you didn't ask them to land on something specific. So given the instructions they gave, what did the jury do wrong here, given the evidence that they saw?
I did ask him that in closing arguments.
Right, but you didn't ask for an interrogatory for them to have to land either unanimously or not on an unreasonably dangerous condition. You argued that there wasn't one wasn't proven. But when you say, well, we don't know what it was, I understand how frustrating when I read the transcript that must have been to try to fight against. What are we supposed to defend? The pallet, the ice, both? But you didn't, as far as the jury was concerned, they heard evidence, they were given instructions, and they came back with a verdict. You both had a chance to argue, but what did they do wrong? What would we be overturning here that they didn't get right?
Lack of evidence. There was a lack of evidence to establish an unreasonably dangerous condition. There was no defect in the pallet. Plaintiff testified. I opened the door. I looked at it. It looked perfectly fine to me. It's a wooden pallet. I've stepped on it many times. I'm in the construction business. This is the same as the Shell Oil case, where the mother and child were at the gas station, and she hopped over the muddy cut in the pavement and fully observed and saw it. That's the pallet. If we look at the ice, we have an even bigger problem. Okay? Nobody ever testified there was any ice on the pallet before he fell. You have to have some evidence as to what the condition is at the very least. The odd thing about it is I couldn't find any case law in Arizona that says that. And I think that's because it's so inherent within the premises liability law. I haven't ever seen it reported. And I do a fair share of this. And I've had a number of appeals on premises where we would have researched those issues. I've never seen it. So I'm assuming it's just inherent that you have to at least start off with identifying the specific defect so that the evidence and the jury can evaluate the evidence of that defect. For nothing else, the duty at the end of the analysis is to reasonably warn or remedy. Well, you don't know what to warn or remedy against if you never know at the beginning what the defect is. And then you can't analyze notice of that specific defect. So,
but if we accept your argument, then would there really ever be liability on a premises owner?
Oh, there always is. Absolutely. It happens all the time.
So explain the gap there as to what's the difference between your position and when there would be liability.
Okay. I had a case before this court 2 or 3 years ago at Phoenix College, and there was a gap in the sidewalk. And the expert came in and measured the gap and found it to be greater than a quarter inch in deviation and found that that was the defect. And then the plaintiff in that case had testified she was walking in that area, and there was also video from the store. The issue before the court was a causation issue, that the court was deciding a legal causation issue. But in that case would have gone to a jury because the summary judgment the court had granted was overturned by the court because of the causation issue. But the defect was identified specifically. It was the crack and the difference in the height of the elevation of the concrete.
Couldn't the defect or the unreasonably dangerous condition just be totality of the circumstances? Does it have to be a specific thing that you point to?
I think it does have to be something that you point to from the standpoint, if you're trying to prove, well, and it depends where you're going on notice. If you're trying to do constructive notice, I think you have to. Yeah, absolutely. If it's something that they created, or you can also verbally admit that you knew that the condition was present. That's another potential issue. In this particular case, there was no evidence of notice anywhere. In fact, the evidence of notice was a video that didn't exist at the time, but was argued over objection.
Can we talk about that real quick, because I see you have less than 5 minutes?
Yes.
And you seem to raise both that you object to, I guess, the lesser sanction. I mean, that it could be mentioned at all, and then you also seem to want there to be some prejudice in the argument that the plaintiff made in rebuttal close, and I'm curious about two things. You didn't object at the time that the plaintiff made the rebuttal argument like, hey, the best evidence may have been this video. And so I want you to comment on either invited error based on the closing argument you gave, asking the jury where is the evidence, and secondly about the fact that you didn't object, and how are we to look at something that is basically the court didn't have a chance to fix at the time?
Well, the court did have a chance to fix it. There was a motion in limine.
Right, but I'm talking about, you heard something come out of plaintiff's mouth that you thought was objectionable based on the rulings the court had already made on this issue that had been widely litigated by both sides, and you didn't object. You didn't object and say, Judge, I want an admonition for the jury to disregard this. I object that he's violated nothing.
I don't believe he violated the court's rulings. I think the court's rulings were so blatantly wrong on this issue that it allowed that to happen. I don't think the
So your position
argument,
now is that they didn't do anything wrong by saying that, because they were followed, that statement in the rebuttal close was fine in light of the rulings the court had made.
Yes.
Okay, that's not what I took from your briefing.
I'm sorry.
And why
I
did you
apologize.
raise that issue in your renewed motion for JMO? I thought you also raised that issue.
The admissibility of the lack of video was raised. The court's ruling on that, he didn't limit what counsel could do with it when he...
Well, he certainly limited what counsel could do with it. He wasn't allowed to give any kind of nefarious intent. He sustained an objection to the very last question he asked the manager, Felix, about the video. You objected. The court sustained that objection because the court said that was outside of what was going to be allowed as far as the video was concerned. So I guess while you have this time, narrow that a little bit for us, because I'm confused. I thought you were raising all over the place that what they did was objectionable and prejudiced your client, and that the jury made a determination based on them raising the video.
I understand the issue now.
Okay.
The distinction is the court didn't allow the video in.
Right.
The video doesn't exist.
Right.
The court allowed in the fact that there wasn't a video. Okay? But did not limit, other than the potential destroying of the video through a nefarious
The adverse
reason.
inference that the jury...
Right. But that had to go with not what the video would have shown. Okay? He allowed the facts in that there may have been a video that showed something, and that was the whole argument for putting it in. Counsel told him, I'm putting this in for notice. During the oral argument about whether or not to admit it into evidence. I have it in the record
Like
here.
you say, the video didn't come into evidence, but the fact that your witness, Mr. Felix, saw the video was allowed to be asked. Mr. Felix is the only one who testified about the video. Yeah, there was a video. I saw the video. It showed basically, here's what it would have shown, but it wouldn't have shown inside the freezer. And those were the questions that were asked of Mr. Felix. And then...
Yes.
Okay.
Yes.
So again, reframe your issue so we make sure we're touching what you're raising.
When the court admitted the video, there was no limitation on the admission and use of the video by the court other than they could not argue that there was some nefarious reason for it missing.
Right.
So at that point, I'm not arguing that counsel's closing was wrong, that counsel violated the court's ruling.
Okay.
That's not what I've ever argued. There is no ruling. He let it in without restriction. He gave the plaintiff a blank board on which to argue what the video may or may not have shown. There lies the problem.
Okay.
That's it.
All right.
Thank you.
Sure.
Good afternoon, Your Honors. My name is Ben Ide, and I represent John Harrington, the appellee and the plaintiff in this matter. Your Honors, Mr. Harrington, on behalf of the appellee, we ask that the court uphold the jury verdict that was given by a unanimous jury in favor of Mr. Harrington, and that the court affirmed the judgment because substantial evidence does exist for the court to be able to uphold it. The standard that we are looking at is there an abuse of discretion? Is there at least some way that even if the court were to disagree with how the jury obtained and what inferences the jury made with those facts, even if the court were to disagree with the conclusion, the court should still uphold the judgment. There's been substantial talk about whether there was actual notice, constructive notice, or the mode of operation, and I would
Well, not mode of operation. I want to try to get that out of the way, because it looked like that was started to be raised in the trial, and then it was kind of abandoned. The jury didn't get an instruction on mode of operation, and it feels like the answering brief raising mode of operation was a little out of place because, and I think the reply brief addresses this quite squarely, but I'm not sure that's right for our decision when it wasn't a theory that you presented to the jury.
And I don't disagree. I don't think that mode of operation is necessary to be able to uphold the judgment.
Well, and I'm saying I'm not sure that speaking on mode of operation is what we would do, given that it wasn't a theory that the jury had at its disposal during the verdict. You didn't give an instruction on mode of operation.
No, but
Okay.
but the jury did have sufficient evidence under which that they can make a determination on liability based on either actual or constructive notice.
Okay.
And it's presumed that the jury would follow that. And I think Judge Hill-Foster, you clarify whether there was ever an interrogatory given. In this case, there was no interrogatories that was given to defendant Circle K or any instructions that the jury could have identified what the specific unreasonably dangerous condition was. And I do think, to your point, Judge Hill-Foster, that the question about whether there's an unreasonably dangerous condition, we do look under the totality of the circumstances. It's not just pointing to one specific thing, one pebble, or one pallet, or one piece of ice. We look at it in totality with the condition as it existed. And on the appellant's opening brief, on page 9, it has a picture of the ice cooler. And that ice cooler, the walk-in ice freezer, is a clear door that shows in the back ice. And there's no warnings that would indicate that any reasonable person should not enter in to grab a bag of ice. Indeed, the evidence is to the contrary, that Mr. Felix has testified, or Mr. Harrington has testified, that other people have gone in there, and even Mr. Harrington has gone in there in the past to grab ice. In fact, Mr. Harrington was also aware that at least at one point someone had been asked to cut one of the pallets to be able to free the ice. So when we look at the unreasonably dangerous condition, whether it's the ice, whether it's the pallet, whether it was broken or not, we also look to where this took place. I mean, conceivably, a swimming pool in and of itself is not unreasonably dangerous. But if there's no fence around it and there's a toddler walking around, that can be an unreasonably dangerous condition. And we look to the circumstances with this. As it pertains to the totality of the circumstances, again, the default will be to the jury in light of upholding the verdict. And even the inferences, the jury is expected to have followed the instructions that were given by the trial court. There was question about whether Mr. Harrington was a trespasser. And that, I think, is also a question for the jury. When Mr. Harrington walked into that walk-in ice freezer, conceivably and apparently he did have that implied notice that, as discussed, there was no warnings, there was no blockades, there was nothing that prevented or gave any evidence that a customer was not allowed to be in the walk-in ice freezer. I think this case follows the line of McCurdy versus Weatherford Hotel, where in that case somebody had gone out to the balcony and fallen. And that's similar to what we have here.
Isn't that case a little bit different? I mean, in that case, you had the hotel proprietor that actually said, go use the balcony to go and smoke, and encouraged her to go out there. I think that case is a lot different. I'd be interested to hear from you about Nicoletti, which appellant is arguing, is similar here. Can you speak to that?
Certainly, and Nicoletti, if I recall, that was the case where the plaintiff had gone through the bushes.
That's correct.
Yeah. So that, so two comments on that. That was certainly, I think, going beyond the scope of the invitation, and I think that's where, and that's not what we have here.
But again, I mean, that's what appellant's arguing, is that your client went beyond the scope of the invitation. So how is that different? How are those two cases different from, or how is that case different from yours?
Certainly, in this case, it was not obvious that this is not a place where a person or a customer could walk. And
what about the evidence that there was a barrier, like a 5? I can't remember exactly. 5.
Somewhere between 3 and 5 inch foot barrier. Certainly, why that is, I mean, I don't see that as that wouldn't. I don't think is to be thought of as a prohibition from somebody walking in. I mean, conceivably, that could be more of a safety portion for the store itself. For example, if the ice freezer were to break, that way that there's not ice that's going and flooding the rest of the store. So that's not, it's not a barrier that certainly could have been up, or a warning that could have been put up, or conceivably a metal door that would have, I think, been more of an indication of a person that's not supposed to be here. And that's when I get back to the McMurtry case, is in that case there was expressed permission. Here, I think it's an invitation, at least an implied invitation, which in that sense is not so different with Weatherford, with McMurtry versus Weatherford Hotel. We have and again, the page 9 of the opening brief would show exactly, we can see that there's pallets, that there's ice that goes further back into the ice freezer, and there's glass doors that can really show how far it does go back. And Mr. Pedix also testified that he is also, and at least Circle K is aware that people do go back there. And now whether there's this warning and whether there's a strict warning given is almost, I think, a little bit irrelevant to the case, because we already have that Circle K has knowledge of people going back there and not taking any steps to pragmatically warn or correct the situation. In this case, we have clear glass doors that are open to the to the customers. Those customers go through, and then this incident happens. And when we're looking at this incident, and I think this is where it's different than Nicoletti, is that this is something that's a store, a proprietor is inviting customers to go into a place to spend their money and to obtain the product, and inviting them essentially into a dangerous area. We've heard testimony, it's in the record, that with the trial testimony, page 60 of the second trial day, that there are jet blowers that are blowing cold air into that freezer. And so we have somebody that does enter into it, maybe cannot see clearly what they're walking into, but at least there's a reasonable invitation that the defendant, that Circle K, is making towards its customers to be able to come in. As it pertains to some of the other parts of this case that at least the court hasn't brought up, whether there's actual notice or constructive notice, too, I think that there's at least enough in the record that would show that there is actual notice or constructive notice based on Mr. Felix's statement that he's sorry that the pallet was broken. The response is, well, that was later clarified, that he's clarifying that was broken. He's sorry that it was broken afterward and not before, though that's not what the jury heard. And the jury heard his response first and then can draw that inference, and they can decide, and they'll evaluate Mr. Felix's credibility. So even under an actual notice perspective, that does exist. Mr. Felix had also testified that such a pallet would be removed and never placed into existence, and then we have a photograph taken hours later that still reflect the ice and a broken pallet that's there too. Combined with Circle K's knowledge that other people had gone into the walk-in ice freezer, had obtained product, this, I think presumably, as I'm looking at appellant's argument, is one of the reasons why it would be attractive to call Mr. Harrington a trespasser under these facts is because there's probably some sort of element of danger walking into a store that has ice and pallets, and by classifying him as a trespasser, there's almost this implicit knowledge that we understand that a person is entering into a dangerous condition. But as an invitee and as somebody that is walking into it, there is a higher standard, a higher duty, and that duty is the same duty that's owed to an invitee, and that the defendant or the appellant the proprietor does have a duty to either warn or to correct of such a condition.
Counsel, I want to ask you about the video argument. How do you respond to the opposing counsel's argument that Harrington violated the court order by mentioning the video and saying, well, the video would have been the best evidence in rebuttal?
So two responses is I don't see that there would be. I don't see a violation of the court order. The court order did give leeway to be able to comment on the video. The jury heard, there's substantial evidence that the jury heard that there was a video, that the video existed, that the video captured what happened, and that Circle K no longer has that video. So there's already substantial evidence under which the jury could make a reasonable inference. It doesn't even have to be an adverse inference, but it can be a reasonable inference that would give rise to liability against Circle K. Does that answer your question?
Mm-hmm. Yes.
With the video, Judge, you pointed out that there was no objection during the closing argument, and I think that portion of that, to the extent that there was impropriety argued, that topic is completely waived. I think in general, when I'm looking at this case holistically, and I would encourage, and I submit that the standard is to look at this case holistically in evaluating whether there's at least evidence under which the judge can, or under which the court can make a finding of upholding the verdict. And that would, and that's when we're looking at the Hutchinson cases. We have that as the background. I think that is the way of approaching this case in upholding the jury's verdict on this matter. So unless there's any other questions, I would yield my time.
Thank you.
Thank you, Your Honors.
Thank you. Mr. Causey? I may scoot into a little bit of your extra time because I'm really I'm back on this. I'm reading your opening brief, and on page 25, you in bold and underline capture the last paragraph of where's the video that would have captured everything, and your immediate sentence after is plaintiff's counsel is clearly arguing that the jury should draw an adverse inference. The argument was a blatant violation of the court's pretrial order. And then on page 27, you repeat the same paragraph, also bolded, also underlined, where you say that plaintiff's counsel's statement amount to an end run around the court's order against instructing the jury to infer that the missing video footage would have been adverse to Circle K. And I thought when you were standing here, you said you weren't doing that.
May I clarify,
Okay.
please? I apologize, I misunderstood your question.
Oh, no problem.
There were 3 judges in this case within
I
the
know.
last 4 months.
Right.
I thought you meant the trial judge's ruling when he let it into evidence at trial. That's what I was referring to. Previously, Judge Bacchus had done an extensive ruling regarding the video and a spoliation analysis.
Right. But what I'm
That's
asking
what
you
the
is on
violations are
appeal,
referring
because it's about me, I want to know what I need to cover when I'm making holdings in this case, and I'm trying to figure out if you thought that the closing argument paragraph referring to the missing video was an end run around any judge's ruling, because that's what you're telling me on
I
2
apologize.
pages in your opening brief. And so I if you're conceding that that's not an argument anymore, that's one thing.
No.
If you're saying that I poorly worded my question and I just want to make sure we're covering what you've raised and not and letting you pull back on what you don't want
No,
addressed.
you did not poorly word your question. I misunderstood
Okay.
it. I should have gone all the way back to the original viewing, which is what that briefing's referring to.
Okay.
If you look at the judge's ruling, she specifically refuses to do a spoliation instruction or
Right.
allow the jury, instruct the jury
right.
that they can
Draw an inference
draw
against your
negative
clients.
inference
Right.
from the missing video.
Right.
Which I believe is where the core problem starts with the judge's ruling to admit it. He never overturned her ruling, and that was specifically
You're talking
asked.
about Gordon, the trial judge.
Yes,
Okay.
and we had another one in between, and I apologize. But her ruling said the plaintiff will be allowed to address the credibility of the video at
Right.
trial. I never offered it into evidence. They did. There was no credibility to contest. I never raised it.
Well, when I think about admitting or offering to admit, there was no video to admit. Nobody's offering the video into evidence. What they were doing was questioning your witness about the fact that he'd viewed the video and what the scope of the video would have shown. This area wouldn't go in here, would be out here, would be for this length. So they raised with your witness that there was a video, that it was missing,
Yes.
and here's kind of the scope of what it would have shown. Period, the end, their last question is sustained, objection, so that's as far as we went until we get to the closing argument.
Correct.
Okay, just want to make sure we're on the same page.
And-
why don't you put a minute back on his clock so he can,
apologize.
has time to do what you want to do. No, I asked a question, you're good.
I'm not watching it, I apologize. Thank you. To try and address that, the point is that evidence was never offered by the defendant, the missing video. I know the actual video doesn't exist, but any evidence about the missing video. So I did not put the store manager on as a witness and say, okay, you watched the video, what did you see?
No, but
And
isn't
now
that
they can-
exactly what Judge, not to interrupt you, I'm sorry, isn't that exactly what Judge Bacchus said, though? Is that, of course, why would Circle K introduce the fact that they lost a video? Of course, it's always going to be the plaintiff. And she was limiting, from what I read, limiting what kinds of questions the plaintiff could ask the store manager, who was the only person who'd viewed the video, and just to get the parameters. So what did you understand her ruling to say that was different from what happened?
Well, if you're going to attack the credibility of the video, and the only evidence that's in the record at that time when she made her ruling is the manager's deposition testimony that the video did not show anything inside the freezer and did not show the fall, I assume she meant if I try to put that evidence on to somehow argue there was no fall, okay, then they could attack the credibility of it.
Okay.
But all it showed was outside the freezer.
Right.
So to me, the whole video is irrelevant to begin with because the conduct that took place outside the freezer isn't one of the issues the jury was asked to decide.
Okay. And so you stood up to make a last point, so I'll let you make it.
It had to do with the video and the spoliation. So I think we've covered it. Thank you.
All right, thank you. Thank you. The case is now with us. We will issue a decision in due course, and we're adjourned. Thank you.